All right, so if you're looking for a video to explain to you what in the world happened yesterday with Pennsylvania lawsuit that we talked about in the video behind me being denied by the Supreme Court, only to be taken up by the Supreme Court on a suit by Texas, which incorporate 3 other states, then you've come to the right spot because we're starting right now. My name is Kyle. This is The Conservative Take. We take culture, TV, movie news, and politics and filter it to you the right way. If this is your first time here, please consider hitting that like and subscribe button and that bell icon so you don't miss any future content. And please, if you want to help join this channel and support us, then please click the join button and do that, and we would really appreciate that. And so I'm going to give a quick summary of what happened in case you don't want to know all the minutia. Essentially what happened, the case mentioned yesterday, we had a video which explained that the safe harbor deadline was approaching and that there was a lawsuit by Representative Kelly in Pennsylvania, which had bounced around a lot. It gone to the Supreme Court. The Supreme Court told the Pennsylvania defendants to give a response by 9 a.m., which they did. And their response basically was like, well, we know that bad things happen, but please don't do anything about it because you're going to open up Pandora's box. That was their response, essentially. Later on in the afternoon, that particular suit was denied and no reason was given. And so here we have this was the big story at the time. And so, but what we didn't notice, or what people didn't really talk about really, was that night before on midnight, there was a suit from Texas that came out, which basically went out against Michigan, Wisconsin, Georgia, and Pennsylvania. And that was actually put on the docket on the Supreme Court yesterday and was voted on, I think 6-3, to be heard. All right. And so that was the story and that was the summary. But where are we right now? So Jenna Ellis, who's the attorney for President Trump, said that the Supreme Court only denied the emergency injunctive relief, not the case itself. She tweeted out this. She says that important point reporters are missing in a Pennsylvania suit. The Supreme Court only denied emergency injunctive relief in the order. It did not deny cert. Mike Kelly, Pennsylvania's suit is still pending before the U.S. Supreme Court. So to summarize this, what they were asking for was to stop the seating of electors in Pennsylvania. Electors are the ones who actually vote for the president. It's a procedure. State legislators are the ones who really are supposed to be doing it, but secretaries of states have been doing it in the past, and Pennsylvania has been doing that. So they're trying to say, look, it's a safe harbor date. That's a deadline of Wednesday at noon. They're trying to stop that so they could have time to present more information and to basically say that this was fraudulent and want the Supreme Court to deal with this. Now, there's something that has to be done for the Supreme Court to actually take these cases, and you have to prove that the case is outcome determinative. And this could be one of the reasons why they didn't take it. But the suit from Texas certainly does. And like I said before, at midnight on Monday, or Tuesday, midnight, there was a suit from Texas where they went out and sued Michigan, Georgia, Pennsylvania, and Wisconsin. And according to Jordan Sekulow, this is the end-all be-all case. So to summarize the summary, Texas took a suit that incorporated all of Pennsylvania's suit, the Mike Kelly suit, as well as Georgia, Wisconsin, and Michigan. And now you have a state suing 4 other states. And that's important to talk about as I go a little further. So that's the summary that I have now, and we're waiting because Thursday, they have to have a response back from that. So let's just see here. Here's what he says here in this article here from the Gateway Pundit. Texas argued these 4 states violated the U.S. Constitution because they made changes to voting rules and procedures through the courts or through executive actions, but these states did not make the changes through the state legislators as spelled out in the U.S. Constitution. According to the U.S. Constitution, state legislators and only state legislators have the authority to determine time, place, and manner for elections. They're also the only ones who can actually appoint electors to Washington to choose the president of the United States. So also, Alan West, who's of Texas as well, came on the Steve Bannon War Room show and said that other states will join on as well. He said as many as 7 will. So Colonel West joined Steve Bannon Tuesday evening on the War Room. He's of the Republican Party Texas state leader, went to discuss today's Texas lawsuit against Michigan, Georgia, Wisconsin, and Pennsylvania at the Supreme Court. He claims that Louisiana will come on board and 6 others will come on board. All right. And so I think he's saying here, Arkansas, Alabama, Florida, Kentucky, Mississippi, South Carolina, and South Dakota. Now, it's interesting to know about this because I didn't know you could have states suing other states. And so I want to leave you with this particular tweet, which is interesting, by a guy named Ron Coleman. I don't know this guy. He's a blue checker. I'm assuming he's got some clout. You know who this guy is? Comment below and let me know his reputation. I'd be curious to know. But what he says here is very, very interesting. He says here in this tweet here that Trump said his lawyers told him he didn't have standing. That basically means you have a case, right? In a big, beautiful suit that covers everything. So Trump wanted a big lawsuit which has everything and give that to the Supreme Court, not just this piecemeal type stuff. Back in November. Now, what lawsuit on God's green earth would be comprehensive but not allow the candidate for president to have standing? So he's saying, what kind of case could you put forth before the Supreme Court where the president has standing but covers everything? He says this one. He says you can only get original jurisdiction, which I assume means you can skip past appellate courts, in Supreme Court in a dispute between the states. The only way to have one big, beautiful lawsuit where a court has jurisdiction over all states is in the Supreme Court. So a state could file the big, beautiful lawsuit, but the president cannot. So the president can't do it, but a state can. And because it's going against other states, it's considered original, which means it goes directly to the Supreme Court. That's how I'm reading it. Only lawsuits by states against states qualify for original rather than appellate jurisdiction in the Supreme Court of the United States. That's why his lawyers said he wouldn't have standing. He points out an article here in Business Insider that Trump wanted one big, beautiful lawsuit claiming the election fraud, but says his lawyers told him he didn't have legal standing. This is what he's referring to. And lastly, he says here, that didn't make sense to me, so I researched it. Well, that's a novel thought. That's when it made perfect sense. And that's been the plan all along. You think it's a coincidence that Texas files midnight before Supreme Court was to consider PA's case? No way. Down here it also says that an Alito doesn't dissent when he already said what PA did was unconstitutional. Once this case was filed, the Supreme Court got the message. They deferred on Pennsylvania just on the injunction request to knock out all 4. And so that's a little wonky here. So I'm going to try and break that down just a little bit. President Trump couldn't present a case that had everything to go before the Supreme Court. That's where you're having different pieces here and there, the cracking here, this and that happening because you just can't do it all in one. But if one state does it against another state, then you can, according to what I'm reading here. Justice Alito said in his Act 77, like a 4-page memo or ruling or opinion, that Pennsylvania had to do things a certain way, that they couldn't violate their own deadline, they couldn't violate their own constitution, and that there will be consequences. All right, I'm paraphrasing that. And so when Kelly's suit put forth this injunctive relief saying, hey, let's stop the seating of electors, that was part of a bigger suit. So when it went to the Supreme Court didn't give a reason for any of it. They took out that part of it, the injunctive relief piece of it, and took everything else, but that was encapsulated with the Texas suit, which included 3 other states, thereby having a bigger suit that the president is not involved with, covers everything, that big, beautiful lawsuit, and now it goes directly to the Supreme Court because it's original. That's my thinking of it, and if that's the case, that is 4D chess at its best. So I'm gonna leave it right there because I don't want to add more, but please comment below in this. If you're an attorney or know more about this, let me know in the comment below if this is right. How's this sound? It's, you know, this really, really interesting to me. And so with that, again, if you like what we do here, you know, subscribe and join and share with your friends. I really greatly appreciate it. Until then, I'll check you guys out next time.